Two of our cases that are going to be important on the exam are Brown and Coppersmith at page 84 and 119. That's how we show cases, as we underline them. I wanted to make sure you understood the difference between jury charge questions and credibility. This is a sample jury charge from my last trial on aggravated kidnapping, and I put it into course documents so you could read it. In Brown, it's the case where the man says he accidentally shot this person in the back because somebody knocked him loose and his gun went off. So the defendant's version was, I guess he had it in some fashion and somebody bumped into him and it went off and hit the person in the back. It doesn't matter how stupid that story is or how much we believe it. The question for jury charges is the issue raised, okay? That's the only question. Before a defense or an intent defense or these voluntary notions or anything goes into a jury charge, all the defendant has to say is, yep, that's what I was thinking, or yep, that's what happened, and the issue is raised. So in Brown, the defendant testified that the gun went off accidentally. That's sufficient to get it into a charge. It is not a comment by the court on whether they believe it or not. That's what juries are for. The same thing in Coppersmith. Coppersmith is the one where he killed his wife or girlfriend by beating her to death on a brick. In the defendant's initial statement to the police, he described banging her head on the ground on a brick and she died. That's murder. At trial, he testified that he just flung her and had no idea where she would land and there was a brick. Obviously, on a credibility test, he fails because he's telling different versions of the story. That's easy to pick apart at trial. But the question the court is asking in Coppersmith is, should negligent homicide be in the jury charge? Should it be in this document so that the jury can consider it at all? And the answer is clearly yes, and it's error not to put it in there. If he says, I didn't know what I was doing, I didn't know that I was banging her head on a brick, oh, by the way, I didn't even bang her head, I just flung her, he's raised it. He's raised the issue because the burden of proof is on the state and the state only. So if the defense raises any issue, it's submitted to the jury as a defense or a question for them to answer. And that burden never shifts to the defendant. So in the I've held this up several times, this is what's submitted to the jury at closing argument, and it has all the law and the questions that they answer when they find someone guilty or not guilty. These two cases are going to be important in your exam for different reasons, but I thought it was important that you understood what they're really about. The court is asking the question, should voluntariness been in the charge? It was not in the charge. At trial, that was an error, and so they overturned it and said it must be in the charge. In Coppersmith, they said, should negligent homicide be in the charge because he denied being aware of what he was doing? The answer is yes, it should be in the charge. It does not for 1 second mean that the court is saying that they believed either one of the defendants in these cases. It's merely saying it's a jury question.